2, 1, go time.
Hi, everybody. It's Laura and Brooke here with MyVirtual.Lawyer, and we're here today for Legal Talk Tuesdays. Today, we're going to talk about contracts. We're still talking to our small business owners, people just in general who conduct business in their lives. This is going to be an important conversation for you. So, is your contract enforceable? So today, we're going to talk about 4 essential requirements for a valid contract.
Yeah, and so contracts, we get asked frequently whether or not people have the correct language, have the correct elements, things like that in their contract. It's very difficult for us to just have a conversation without looking at it and telling you. But in general, the first thing that starts the whole contract process is that you get an offer from one party. And we all pretty much know what that is. We've had various experiences through our life with people making offers. So that is when someone makes a clear offer to enter into an agreement with you. And so this can be in writing or spoken. I know sometimes people don't understand that you can actually verbally create a contract, but that can happen. How long is the offer on the table? That's another thing that is sometimes difficult. Unless you actually put an end date and state it, then the end date of an offer is going to be a reasonable amount of time, which could you be any more vague? So reasonableness is going to depend on different things, the situation, the type of business that you're in. So it's best practice tip from us. If you are entering into a contract with someone, make sure that if you are making the offer, put in there an end time, or if you're reviewing an offer, that there is an end time there to either accept or reject that offer. Another thing that people run into is when can you cancel an offer? So, say for whatever reason you decide that you have made this offer and you want to withdraw this offer, or someone has made an offer to you and they no longer want to go forward with that offer. You can actually cancel it at any time as long as it hasn't been accepted yet, except for if there is an actual end date, a cancellation date. So if you've given them 30 days to respond, you have to wait until the end of that period of time before you can cancel it. So kind of to give you an example, because it's easier to give it an example form. Think of it this way. If you're going to order, say, straight edge business cards, and your printer says it provides you a written proposal for 500 business cards for $100, then that is his offer. That is an offer. So on the other side of that, you can't have an agreement if you don't have an offer and an acceptance. So for the acceptance side is once you actually agree to that offer that was presented to you, you have accepted it. So once you approve it in the eyes of the law, then you've actually created a contract. You've entered into that agreement, and both parties are then responsible for completing their end of the deal. So the printer will print and you will pay whatever fee, the $100. When is it not an acceptance? So if you respond that, this all sounds great, thanks, but I want to shop around, or before you've accepted that, then you've not accepted that offer. It's not been accepted. Or if you actually, in response to that, change the offer, then if you say, oh, that sounds great, except for instead of the straight edges, I want to do round edges on my business cards. So then there's not a contract made because you've actually changed the original offer, and likely that's going to constitute a counteroffer. And so when the counteroffer is made, the legal responsibility to accept it shifts back to the person who originally made the offer, and they can either accept, decline, or counter your offer with something else.
Exactly. And so let's going with what Brooke was talking about. There's an offer, there's an acceptance. The third thing that you have to have is a mutual agreement. So if an offer is made, those terms are accepted, then you have a mutual agreement. The definition of a mutual agreement is it's a contract becomes legally binding once the offer is made and the other party agrees to all of the important terms of that particular offer. Differences in like if you make small tweaks to offer and acceptance, then that's not necessarily going to negate. It's not going to void the contract. So you don't have to worry about saying, hey, with the business card example, I wanted actually I can't even think of a small tiny thing with the business example, but let's use a totally different example. So for tiny unimportant changes that won't negate a contract, a different example would be it's lunchtime, let's talk about food. So if you call like a deli or somewhere in town and you offer to buy 10 turkey sandwiches on Texas toast, the owner of that or the person that you speak to comes back and says, I can provide 10 ham sandwiches on Texas toast, then there's been an offer, but there's been no acceptance of that offer because they changed a very important term, meaning they only had ham, you wanted turkey. So there's been no mutual agreement there. If, for example, the person on the other side says, yes, I can definitely make you 10 turkey sandwiches on Texas toast, then a valid contract exists. And you can't later say, after you've gotten the sandwiches, you can't later say, I don't want to pay you because that Texas toast wasn't as thick as I wanted. It was too thin, because that's just a tiny little detail that is really kind of unimportant to the enforcement of the contract. So that's kind of a little bit of nuance to that mutual agreement. If it makes you feel better, contract law is one of those things that I have friends who've done 4-month trials seriously on one clause of a big contract, because that you have to be really careful about your language and what that says. The last thing that's important for a valid contract is something called consideration. Now, I'm using that legal word because that is a word that the lawyers use, that the laws use. Consideration basically means that something of value is exchanged for performance of the contract. That can be money. It can be, if Brooke and I, we deal sometimes with other professionals who, we do this for you, you do this for us, and, no money exchanges hands, but our value comes from our skills, our education, whatever it might be. So in addition to having that mutual agreement, the contract is not really valid unless the parties exchange something of value in anticipation of the completion of that contract. So examples here, let's go back to the business card example. We'll switch out of the toast example here. So let's say that the printer has promised 500 business cards, and you promise to pay the printer $100 for those 500 business cards. That's offer, acceptance, mutual agreement, and that promise of, yes, I will pay you once you complete the job is the consideration, that value that has been proposed and promised for that particular contract to be finished. What is a gift versus consideration, gift versus contract? A lot of this is going to, to deal with that value, that consideration. So a gift versus a contract, the main important thing is that value, that consideration, if it's exchanging hands. So if there's a one-sided promise, if there is a statement saying, hey, I'd like this, then that's not a contract that's enforceable by law. If you offer to help your friend rake leaves or mow grass or something like that, and that, but with nothing in exchange, then that's just a promise. You've offered to help them with nothing in return. If instead you offer to help your friend rake leaves or mow your lawn, but only if they help you clean your house, then that's a contract. That is something that you are offering to perform for them if they help you perform something that is of value to you. So you got to kind of think about contracts are a little sticky sometimes, and that's why talk to an attorney. Promises versus actions is another thing, because we're talking about promises when it talks about the raking the leaves and things like that. But promises can be, can get you in a little bit of trouble depending on the situation as well. Promise, if you're exchanging promises for future things that are going to happen, then that usually satisfies the requirements of a contract. And we're talking a little bit small end here. I wouldn't necessarily make a promise to pay somebody $1 million for something. You need to have some stuff in writing there and, some money changing hands. But instead of, let's say I made a promise, but nothing ever gets done and neither party is upset, then that's totally fine. But if you make a promise and there is work performed on the other side, so that's promises versus actions. If there's work performed on the other side and you don't want to fulfill your promise, then that is you breaking a contract because they have already performed part of their promise to you. And you are then saying, oh, I changed my mind. You can't do that. So again, an example with the printer, if you call the printer and say, hey, out of the 500 business cards, I want 250 of those business cards to go to this different address because Brooke and I live, 12 miles apart. I don't want to have to drive to give her the business cards. So I want 250 business cards to go to her address, 250 to come to mine. Let's say the printer ships 250 business cards to Brooke, then he's already fulfilled part of his promise and that contract cannot then be canceled by you because he's performed an action that says that it's a valid contract. So I know it's a little bit, it can be a little bit complicated, which is why we encourage you to speak to an attorney for anything related to contracts of value to you and your business. So offer, acceptance, agreement, consideration, those are things that are required for a court to uphold a legally binding contract. And again, you can kind of hear from the examples that we've used and the language that we've used that it's not as easy as it sounds. So just keep that in mind.
Yeah, hopefully we made it a little bit simpler to understand, but these are the 4 core requirements. There are other things that we didn't get into because we didn't want to convolute this whole conversation. But like Laura said, if you need any assistance, have any questions with that, just feel free to reach out to one of us. So thanks again for joining us today. We're here every Tuesday. We'll be back next Tuesday at 11:30 for Legal Talk Tuesday. And we are going to switch gears a little bit because this has surprisingly to us become kind of an issue that we've been made aware of, and it's happening more frequently than we would like. But we're going to actually talk about the unauthorized practice of law and what it is, why you shouldn't do it, and why you should avoid getting legal help from someone who is. So join us next week, and thanks again.